discipline bill, and we have taken public comment. We are now on committee directives. Committee, what is your pleasure? Bill has been moved and seconded. Any discussion? Senator Scott.
Mr. Chairman, are you ready for amendments? Or do you want to do a general discussion?
Quiet. Anytime you're ready.
Mr. Chairman, I've got 4 of them. First one I want to do is potentially it's on page 11. It's relating to the language that is being repealed. There was a suggestion on page 11, line 3, that we reinstate this section without the word corporal in it, repeal that word. My question for the legal counsel is that already covered adequately in the Governmental Immunity Act for the state? And so is it, because you'd have a very broad immunity statement if you did what was suggested, and take the word corporal out and reinstate the rest of it. Is that already covered? And do we run any risks if we do that of causing trouble with it not being quite identical with our Tort Claims Act, or is it identical?
Madam Chairwoman, Senator Scott, great question. I think we did address this at the August meeting, and my advice was there is a potential conflict between the Governmental Claims Act and this provision if it differs in any way. And I don't know that it does, but in response directly to your question is yes. School districts are within the protection of the Governmental Claims Act. They are an entity, and unless it's an intentional tort or something like that, there's obviously a laundry list, but specific to school districts, unless there's an intentional tort, they would be covered by that act.
If it's already covered by the Tort Claims Act, I'm not going to move that we change it. I think just repealing it, we're fine. Sometimes get tempted to repeat something so that the teachers all get the word, but I think we may be running some risks in this. And I think some of the problem, if there is a problem, would be federal law and getting sued for denying somebody their civil rights, and we can't touch that anyhow. Mr. Chairman, on that same page, there was a suggestion that we remove the repealer that would have repealed what's shown on page 11, lines 6 through 10, which the issue is the indebtedness. Mr. Chairman, I think that's separate from the subject matter of the rest of this bill. And let's remove that repealer, reinstate the existing language, which is what we do if we remove that particular repealer. And I think we're fine. I think that if somebody wants to change that, that's a different bill. So that's my motion. Mr. Chairman, it is a need the districts have, and as was pointed out, it can be not just little indebtedness, but equipment of significant value that the kids are not returning. It does give them a handle to get things settled up, and it would strike me that a competent district would seek to get it resolved before it came to the you can't walk at graduation stage, but they need that threat to make it work. So urge adoption of the amendment.
Further discussion.
Mr. Chairman.
Senator Office.
I'll support the motion because I think it's outside the bill, so I think it's appropriate, but I'll just say I disagree with the policy. So if we were having a policy debate, I'd argue it, but I think Senator Scott's right that it's outside the scope of what we should have in the bill. So I'll support the motion.
Further discussion. Seeing none, all those in favor of Senator Scott's amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted. Further amendments to Senator Scott.
Chairman, page 7, lines 19 through 20, and page 8, lines 1 and 2. The issue here is the minimum of 1 planning period. I'm going to, frankly, I think that the problem here is we're getting into the district's business with their teachers in an area that's not fully relevant to the bill. So I'm going to move that we delete those lines from the bill.
Moved and seconded. Any discussion? Representative Kelly.
Thank you, Mr. Chairman. I have my notes almost exactly the same thing that Senator Scott just said.
Further discussion? Seeing none, all those in favor of Senator Scott's amendment, say aye. All those opposed, no. Amendment is adopted. Senator Scott.
Mr. Chairman, on the final one, and this one's a little different because I want to add something. On page 4 in this list of things that school district employees can do, you'll see the lead in on page 3, lines 11 through 14. I want to add a new starting about line 4 on page 4, add a new subsection capital B, and then you have to renumber the subsequent ones. And it would read, informally discuss behavior and discipline issues regarding a pupil with that pupil's parent. And then second sentence, the district may make exception to this provision if necessary to comply with other valid law. And the other law would probably be federal. And then we had a specific example cited when we talked about this earlier. So give the district some flexibility if they have a legal problem, but tell the teachers and the other employees, yeah, you can talk it over to the parents. And what I'm hoping is this will give a push to what a number of them do anyhow, which is try to get the thing settled informally between the teacher and the parents, and have the teacher and the parents dealing with the kid as a team.
Senator Scott, can you repeat the actual addition to the statute?
Okay, it would be on page 4, line 4. Add a new capital B provision. Informally discuss behavior and discipline issues regarding a pupil with that pupil's parent. And then new sentence, the district may make exception to this provision if necessary to comply with other law.
Would it be a friendly amendment to use the word student? I think that's in the rest of the statute, rest of this bill, the word student instead of pupil.
Pupil, that's fine.
Okay. Just to conform that. Is there a second? Moved and seconded. Any discussion? Senator Olson.
Senator Scott, what I'm a little confused on the use of the word informally and why that's necessary, as opposed to just allowing the teacher to, your goal is to allow the teacher to talk to the parent. I
Yeah.
think you can just say that unless there's a reason for it, but for informality.
Senator Scott.
Mr. Chairman, I put it in there simply because I didn't want anybody to think they had to go through any kind of formal process to do it. What I really have in mind is calling the parent up or seeing them after schools, as happens in our one-room country school.
Okay.
But if you think it covers that adequately, I wouldn't have any problems if you thought it'd be better without that word.
Senator Olson.
I think it's covered by language just saying that the parent can speak with them. I just worry about that causing, frankly, ambiguity from the teacher's perspective of what does that mean informally?
Okay. Mr. Chairman, I
Senator
think that
Scott.
if you allow us that to be considered a friendly amendment, we'll just do away with that word.
Sounds good.
Further discussion? Senator Rothfuss.
I guess I don't know what the amendment's specifically going to do that can't already be done, but regardless of that, I guess I just request Senator Scott provide some flexibility to staff to conform the language a little bit, because rather than valid law, usually it's to comply with state or federal law, something along those lines. So we have terms of art that we typically use in statute. Would that flexibility be acceptable to ensure that it comports with standard statute?
That's all.
Right.
Friendly? All right. Further discussion? Seeing none, all those in favor of Senator Scott's amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted. Further amendments, discussion? Representative Lawley.
Thank you, Mr. Chairman. This will be a little bit conceptual as far as the wording. And on page 9, line 13, I would like to insert a new section M and then renumber accordingly or re-letter accordingly. And what I want to do here is address the issue of parental involvement in consultation and notice and then consultation / involvement. So what this amendment would do would give some parameters on the notification of parents or guardians of actions taken in accordance with the statute and require involvement and consultation with parents in the imposition of any consequences. So again, it's somewhat like what Senator Scott was doing in an informal way, kind of upfront, but to put within this process, and again, Tanya will work with me on the wording exactly, but that's what we're trying to get at, that it's just throughout the statute. I think in many districts, this is already happening, but because we have had questions by parents, and even the teacher in her parent capacity mentioned the importance of those things for there to be maybe a good resolution of these issues, or a resolution that will be effective and give the parents to have that. So that's my amendment, and I'd ask for a second.
Moved and seconded. Any discussion? Senator Scott.
I'm sorry, I'm lost as to exactly what the amendment would go in, what it would really do.
Representative Lawley.
Thank you, Mr. Chairman. Senator Scott, on page 9, line 13, we would insert a new M, small m, and then, of course, re-letter the other M. But, and that would be just a provision that relates to the whole statute about parental notice and consultation.
Further discussion? Representative Lawley.
Thank you, Mr. Chairman. Tanya actually raised here the idea of, what does this conflict with Senator Scott's amendment? Certainly isn't my intention to conflict with that, in that I felt like he's inserting into the very beginning one opportunity for some informal, I think we took that word out, but the intent was that it would be an opportunity on the front end to get involved. What I'm proposing is more comprehensive than that, and I don't think it conflicts with that, because it's the same idea involved, but it says in really these processes that will be noticed to parents, and they'll have an opportunity for consultation in the process. So I don't think that conflicts, but I'm open if you have a thought on that, Tanya, that I'm not getting.
Mr. Chair, Representative Lawley, I don't know that it is inherently in conflict, but it's certainly the same concept. And so if you're going to have notification or involvement provisions, it might be helpful for purposes of organization of the bill to have those in the same place.
Yeah.
Rather than, this is inserted here and then there's a comprehensive notice at the end. I think that might cause confusion from a practical sense in implementation of the bill.
Yeah, point taken. I think that's something the committee needs to consider. If we do this comprehensive amendment, which we did not have when Senator Scott made his suggestion amendment that we did pass, whether or not this would be sufficient to cover that. And I think that's a policy decision for us to make, if we think that it should be there too, and then here. But definitely, I do strongly want and support the idea of a statement that is comprehensive and applies to the entire bill in terms of the various discipline processes. So that's what I'm going for. But I guess Senator Scott can say whether he would think that whether doing this amendment I just proposed and is on the table, whether or not you feel what you had proposed and we passed is needed now. That's not a decision I can make.
Senator Scott.
Mr. Chairman. My thinking is we're better off with both of them because this does refer, as I understand the amendment, to the much more formal processes of parental notification and whatnot. And as I remember that bill, there are some constraints and times and whatnot. And the proposal I've got really does deal with call them up and talk to them, much less formal. So I think it's useful to have both.
Representative Lawley.
And again, I think that's fine. I think what we're doing here is adding a provision that is not directly relating to or referring to the parental rights bill. It's just simply saying within the statute, we're just clarifying, because I do think there's a gap. We don't mention specifically disciplinary actions. And again, that might be something I take up with the personal bill in the parental rights bill. So we have a gap, no question, legally there, I feel like. So I'm trying to fill this gap with a rather broad provision that I think would apply to formal or informal. It's basically because it would apply to anything in the statute. So, but I'm okay if you want to keep it in. I just feel this is more comprehensive. And so I think we really do need it based on the testimony we've heard from parents. So.
Further discussion? Seeing none, all those in favor of Representative Lawley's amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted. Further amendments?
Oh, do you want to go ahead? No, because I've got a few. Go ahead.
No, that's fine. I'll see what you're talking about.
I was going to say the same.
Co-Chairwoman Schuler.
Okay, thank you, Mr. Chairman. These might not be in order. Page 2. I'm going to try and make this pretty simple. We talked about all school district employees. Would like to see us delete all. And I thought about changing, adding in there supervisory authority. But I think if we just take away the word all, because down on on that same page on line 20, it talks about those students that are placed under their supervision by the school principal. I know there was issues we were talking about janitors, we were talking about, everybody else. But I think it also it does kind of help our transportation people to feel like they maybe have some backing on this as well, without having to add that in someplace else. So I would just like to have us take out all and just say provide school district employees with, and you can take out if you want, just with authority to enforce the rules to students placed under their supervision, which I think is the big deal there by the school principal, the principal's designated. So I'm just going to make it a real simple one for starters, if there's a second.
Second.
Okay.
Moved and seconded. Any discussion? Seeing none, all those in favor of Co-Chairwoman Schuler's amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted.
Okay, and this one we may, I'm certainly open. This would be page 4, where we got into the really prescriptive words. So on line 11, I would like to see us take out disobedient, and number 12, or on line 12, disrespectful. and leave in violent, abusive, or disruptive. Yeah, I don't know. What do you think about that? I'm open for that. Do you guys want to keep that one in? Yeah, okay, let's leave that one in. So it'll just be taking out disobedient, disrespectful. And leave the rest of them in there.
Representative Strzok.
Thank you, Chairman. I feel like anyway, can't even get it out at the moment. No, disruptive. Thank you. Disruptive students. I think that needs to be taken out
Taken out.
because I think that was too broad. Anyone can be, you can just, I had a son that honestly would just sit there and wouldn't do anything. And I was told he's disrupting. I don't know why I'm struggling with that. I think maybe I need speech class. Anyway, and they said because he wasn't doing a thing, but
I consider that friendly.
So, Mr. Chairman, I read this paragraph as having two parts to it. Or it could have two parts to it. I think the problem is we want disruptive students to be removed from the classroom. That's a core issue. But we don't necessarily want someone to use reasonable force to remove a disruptive person. So what I'm not seeing in this bill is just the general authority to remove a disruptive student from a classroom, which might sound broad, but if you're not using reasonable force, I don't think there's a problem with that. I think if a kid is disrupting the learning of other students, they should be removed from the classroom. So I don't know how to marry that with your amendment in this paragraph in particular, but I think disruptive is really important because it does categorize a lot of students, but it is also a key problem that we see teachers having. I just don't want someone using reasonable force to remove someone who's, talking too much, for example.
Mr. Chairman, could I opine on that? What if we went with removal of violent, abusive, uncontrollable, or disruptive students from the school district property, period, and strike the rest of it? Because reasonable force seems to be an issue that a lot of us are having problems with. I don't know.
Actually, Mr. Chairman, that might be a good way to bifurcate this, because then the second half of the paragraph, you could leave the reasonable force clause there, and we could tailor that so that there's two different things happening. There's removal from a classroom, and then there's this paragraph about using reasonable force to remove, but only under the circumstances that are delineated in the statute. So I'm not sure when you said delete the rest, you meant delete the rest of the subparagraph or just up to the period?
I like what you're saying.
Okay.
I'm sorry, Representative Bratton.
Thank you, Mr. Chairman. I did want to just briefly talk about the reasonable force because I was talking with the department and they said under the rules that were promulgated pertaining to seclusion and restraint, that's already prescribed in law. And we just want to make sure that that dovetails smoothly with this. Like they still, the term reasonable force is already, that rule is already promulgated. And I'd just like to confirm that is the case with the department, since there was a concern about it.
Thank you, Mr. Chairman, through you, Representative Bratton. Dickie Shaner, Department of Ed. We do have chapter rules based on statute related to seclusion and restraint with some specific things in terms of us looking at policies that districts have related to seclusion and restraint, ensuring people are trained in that. Primarily, it's a special education policy, but I think occasionally it can expand out to a severe mental health situation or something of that nature.
All right, thank you.
Any questions?
I do.
Representative Lawley.
Thank you, Mr. Chairman. I want to make sure I heard what you just said, right? That you have some policy language, but it really relates to children on IEPs. Did I hear that right?
Mr. Chair,
Dr.
through you,
Schneider.
Representative Lawley, my understanding is that the seclusion and restraint statutes and the Chapter 42 rules that go with it are primarily for special education situations.
Okay. Okay. So we've already concluded this bill does not cover special ed because it's covered by the federal statute. So I guess that's where I'm wondering if what you have in rules is already in place for non-special ed. So, we might not need some of this language. It already exists. Because I do think there's something here about reasonable force that's important in terms of protecting teachers, because you can say, well, you just take them out of the classroom. Well, usually if it's a really disruptive situation, violent situation, that child if they're going to get up and leave the classroom because you told them, likely you don't have the problem you think you have. Like there's typically, these are situations where there is going to need to be a physical removal, or could be. So I guess I'm wrestling in with the rule issue, because I don't think the rule issue sounds like covers what's in this bill, in the sense of it's not special education situations.
Mr. Chair, through you, Representative Lawley, I think I would agree with that. The Chapter 42 rules we have are pretty specific to the seclusion and restraint, and that the bill you're currently discussing is broader than that. So the rules that currently exist would not account for the new bill.
Sorry, Senator Brennan.
Thank you, Mr. Chairman. If it would be friendly to this idea, what I would like, if we look on line 13, it says students from school district property, but I think that we're not trying to remove school students necessarily from the district property, but from that area of disruption. And so if there's a little bit better language, but what I would propose is that we put after from, insert area of disruption on school district property, allowing then the student of disruption to be removed from that area, whether it be the classroom, the gymnasium, the athletic event, the lunchroom.
Makes sense.
And then we would also need to insert that language on line 15 after the word from. And so what I have so far as what we've talked about is that then this would read removal of violent, abusive, or uncontrollable students from the area of disruption on school property, period. We'd strike using reasonable force. And then we go on to say reasonable force may be used by school district employees to remove a student from, insert the area of disruption on school district property. And then the rest of it would be left in. And then I think if we needed to address like the disruptive students, which I would agree with, that we could then come back and put in a Romanet 2 for disruptive students.
Consider that friendly.
I'm curious if Ms. Hytrack has any thoughts on this.
Mr. Chairman, I just wanted to clarify
Oh,
that
I don't know. I thought we did.
21.3.110 A Romanet 31
Oh,
is
sorry.
not explicit to special education students. There's actually a provision that reads, the policy shall not be limited to any specified group of students and shall apply at any time that seclusion or restraint is used for a student. And restraint means the physical force with or without the use of any physical device to restrict the free movement of all or a portion of a student's body.
See, this is.
And seclusion means removing a student from the classroom or other school activity and isolating the student in a separate area. I
Thank
think those are important provisions that overlap with some of the concepts in this bill.
Thank you. So I believe we have an amendment that has been moved and seconded. And Senator Brennan.
Thank you, Mr. Chairman. I I think I had taken out disruptive, but I believe we left the disruptive in. Okay, my apologies. I like the disruptive in there, and then we don't need to do, then we don't need to go into a Romanet. Perfect. Double I. Thank you.
Further discussion?
Mr. Chairman,
Senator Scott.
can we have either the sponsor or the LSO read us back the amendment? Because I'm a little confused as to what's in it and what isn't.
Senator.
Certainly, Mr. Chairman, Senator Scott, it will read on page 4, starting on line 11, removal of violent, abusive, or uncontrollable, violent, abusive, uncontrollable, or disruptive students from the area of disruption, from the area disrupted by on school property, something to that effect, period. Striking using reasonable force, and then the next sentence would read, reasonable force may be used by school district employees to remove a student from the area of disruption. That's what the term is, from the area of disruption, on school district property to prevent injury of the student or others, maintain the opportunity for all students to learn, or to ensure the safety of students and school district employees. And Senator Brennan, please correct me if I got that wrong.
Is that your understanding, Senator Brennan? All right, further discussion.
Mr. Chairman,
Senator Olson.
sorry. So then I think in the second part of this subparagraph is where we can control the circumstances for reasonable force, and it may be a little too broad. So there's 3 categories that you can remove a student with reasonable force. One is to prevent injury. I think we can all agree that makes sense. The last one is to ensure the safety of students and school district employees. That one makes sense. The one I want to challenge is line 17, to maintain the opportunity for all students to learn. That's probably not where you want to use reasonable force when it's just, the classroom's disrupted, sure, but does that warrant the level of reasonable force? I would say no.
I would consider that.
Further discussion. Representative Bratton.
Thank you, Mr. Chairman. So am I understanding correctly, 21-3-110 to 31, if those rules that are promulgated are not limited to special education, so this question is for LSO, doesn't that mean they still have to follow those rules that are promulgated? And the reason I'm asking that is when I went into my schools and they showed me the rules that were promulgated in the booklet that shows how they escalate the use of that reasonable force. My understanding is the pictures I saw, first you go in and they just stand there and they look at the disruptor, and then they move in closer to the disruptor. And those of us who have been teachers know how this works. And then if they have to, then they actually would stand on either side of the child, say, all right, you need to come with us. If they don't, then they would actually physically remove them in the way that they've been trained. So since this rule that's promulgated, or since this still is in effect, don't they still have to follow that policy with these kids, or am I misunderstanding that?
Mr. Chairman, Representative Bratton, yes. This law has been in place since 2011. There are specific requirements associated with it. The state superintendent, as Mr. Shaner indicated, is required to promulgate rules. They're also required to take a look at those policies, and in the event that they are not adequate, they can implement corrective action. And so then when you look at 21-3-110, there are specific requirements associated with physical restraint, which is very similar to reasonable force. And then seclusion is basically the last point of Representative Bratton's scenario, where the student is removed from a classroom or other school activity and isolated in a separate area. And I can't speak to the specifics that have been adopted by school districts, nor the rules, or those that have been, presented to the Department of Education, but that is what the law requires.
Thank you. Representative Lawley.
Thank you, Mr. Chairman. So, you know, should we be trying to like have these rules in place and then have a provision in here that at least has a different nuances to it and maybe even in conflict? Or should we just refer to that? And somehow that, you know, I don't, I mean, I think this is an important question.
Mr. Co-Chairman, if I could, I think the issue is, I think we're trying to complicate it again because up above, these are the sections that they're talking about here. The conduct is already, that's a student code of conduct that's already adopted by a school district. It may include any of the following. So school districts have their own discipline plans, their own way of dealing with things, whether they have a matrix or whether they have a certain level. So again, I think that may up there may be the thing that we're looking for. We're not saying they shall do this. We're saying they may based on their school district policies. I don't know if that clears it up for everybody or if it makes it worse. Maybe Tanya can help us on that.
Mr. Chairman, Madam Chairwoman, I agree that on page 4, line 14, it provides that reasonable force may be used, and that's a permissive inference for school districts. The issue that I see is that there are seclusion and restraint requirements already contained in statute, which refer to the removal of a student or placing that student in isolation. And my understanding is, at least with regard to this provision, that's an overlap. And so what you could do is refer to those rules and regulations, or, you know, perhaps there's a distinction that I'm missing that the department could testify to with the practical implications. I can't answer that last part. I just know, you know, this is what the law states.
Mr. Chairman,
Senator Olson.
can we ask the district, since you worked on this language, is the reasonable force section of this subparagraph necessary? And if so, why, how does it differ from the existing statutes on seclusion and restraint?
The department.
Said districts, department.
Well, yeah, I thought you worked on this language. Did I say the districts?
Yeah.
Sorry. It's late.
Mr. Chairman, Senator Olson, I missed the first part of the question, if you don't mind.
Yeah, so it seems like the seclusion and restraint statute and rules and regs are doing the same, are accomplishing the use of reasonable force. So my question is, in drafting this language, do you see that we would be gaining something more from using this definition of when reasonable force can be used, or can we just delete it and stick with the existing statute that we already have when force is used?
Mr. Chair, through you, Senator Olson, I don't know if I can answer that on the fly right now, but it seems like a good question.
That's
I'm
fair.
yeah, chapter 42 are the rules that we have on seclusion and restraint. And they are, I mean, there's 8 pages, definitions and processes to use. So there is a lot of overlap.
Senator Scott.
Mr. Chairman, let me suggest that if there's uncertainty here, we're probably better off leaving our provision in the way we want it, and then we'll hear in first committee whether we've messed something else up and whether we could get by without it.
Madam Co-Chair.
Yeah, good co-chair and I were just discussing that we could just amend it to follow what you have in statute. Or we could leave it as is with some amendments and then try to fix it, in committee. And, I could go either way, so I could withdraw it, or if you feel like we're okay to leave it in, and maybe Tanya could address this and then work it later. What's your feelings on that, either group?
I'd defer to LSO on that.
Mr. Chairman, Madam Chairwoman, I think one way to tackle this is, and, taking into consideration Senator Brennan's amendments, is removal of violent, abusive, or it's not or now. Violent, abusive, uncontrollable, or disruptive students shall comply with those statutory references and the rules. And then we can modify the second sentence to accommodate that reference as well. That's the best language I can come up with on the fly to refer to those. So, and then with the latitude to make conforming amendments if necessary.
Madam Co-Chair.
Mr. Co-Chair, that's exactly what I wanted to say, was that I just needed somebody smarter than me, who you are, most of you in this room, probably everybody. I appreciate that. And I will make that amendment based on LSO's.
Moved and seconded. Is there any discussion? Seeing none, all those in favor, say aye. All those opposed, no. Amendment is adopted. Further discussion?
A couple more, if you don't mind. I
Madam
think
Co-Chair.
it'll be easier though. And a couple of these were suggested by our state school boards folks. Over on page 5, on line 9, I think we can delete the Board of Trustees on both line 9 and line 12. I totally agree with their advice that that's another layer that we don't need at the particular stuff that we're talking about. So if there's a second, I would say we delete both of those.
Moved and seconded. Is there any discussion?
Mr. Chairman, if you could restate, Madam Chairman, where that amendment is at, I apologize.
You bet. In wrong page now. I started moving on to my next one. Page 5. Page 5. So it would just on page on line 7, or excuse me, line 8, you would just have the school principal or the school district superintendent, period. Well, not period, just that they shall consult. And then over on that same page, line 12, again, the principal or the school district superintendent, and scratch out the Board of Trustees. Does that make sense?
Further discussion? All those in favor of Co-Chairwoman Schuler's amendment, say aye.
Aye.
All those opposed, no.
Couple more, and then I'll quit.
One point of clarification on that amendment, page 5, line 2, also discusses referral to the school principal, school district superintendent,
Oh,
or the
yep.
Board of Trustees for
Yep.
behavioral modification.
Please, yep.
I
missed
presume that's
that.
a conforming amendment. Thank you.
Yeah. Yep, absolutely. Thank you. My next one, again, I want to say simple, page 6, I think, line 8, I think we should just delete the word written consent for the classroom teacher and just leave consent. That way, a principal could visit with the teacher. That's good. Okay, great. We don't necessarily have to have it in writing. I think that's just another one of those things we don't necessarily need.
Moved and seconded. Any discussion? All those in favor of Co-Chairwoman Schuler's amendment, say aye.
Aye.
All those opposed, no.
No.
Amendment is adopted.
And I think I've just got one more, if it's okay, Mr. Co-Chair.
Madam Chair.
Page 6, line 13, seemed to be that we didn't really need 3, little I. little I3, excuse me, implementation of dropout prevention or an academic intermission program didn't seem like it fit or we need it necessarily there. I would just say we delete that. Page 6, line 13, three little I. Implementation of dropout prevention or an academic intervention program.
Moved and seconded. Is there any discussion? Seeing none, all those in favor, say aye.
Aye.
All those opposed, no. Amendment is adopted. Are there any other amendments?
Except I had one more. Sorry. And I'm probably taking some of yours, or am I taking some of yours? I hope not. If you don't mind, one more on page 7, where line 6, where it says immediate assistance. And I would like to add, delete that and put as soon as reasonably possible. Does that make sense? Soon as reasonably possible. Yeah.
Receive.
Does that make sense? Sometimes I'm not a wordsmith.
Receive assistance as soon as immediately
Correct,
possible
immediate.
from the school district. Is that-
Shall receive,
that's all right.
shall receive assistance as soon as reasonably possible.
Moved and seconded. Is there any discussion? Seeing none, all those in favor of Chairwoman Schuler's motion, say aye.
Aye.
All those opposed, no. Amendment is adopted.
I apologize. I did have one more. Didn't go far enough. Sorry.
Co-Chair Schuler.
On page 9, it's just a word. And it was the reporting. Where on line 18, it says that the state will have to report districts, all student disciplinary actions. And I would like to delete all and just put major student disciplinary actions. On, again, line 18, page 9.
Moved and seconded. Is there any discussion? Seeing none, all those in favor, say aye.
Aye.
All those opposed, no.
I'm done.
Amendment is adopted. Any other improvements to this?
So I don't,
Go.
Mr. Chairman, I don't have the language, so I'll have to rely on LSO, but I think we want the data that's being reported to be de-identified. So we just need to specify that whatever the data is that's being supplied to, whether it's the trustees or to us or reported to the Department of Education, that it's de-identified.
Do we have a second? Moved and seconded. Is there any discussion? Seeing none. All those in favor of Senator Olson's amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted. Representative Lawley.
Thank you, Mr. Chairman. I would direct your attention to page 3. And this is something that Tanya brought up when we went through the bill. And I think she's right as far as the way this flows. So what I would recommend is on line 3 of page 3, after district personnel, to insert lines 11 without the designation of what I erased it, but the Romanet 2, delete that out, but that section come up and be inserted on page 3, line 3, after the word personnel. And then we put the Romanet 2 in front of the word for and to make a new section of this. And it just kind of reorders, I think, in a way that makes a little bit more sense. And I think I got it right, Tanya. You might want to check me, but I think that's what I heard you saying.
Mr. Chairman, Representative Lawley, is it your intent that those provisions at the bottom of page 3, I guess through page 5 would fall under that new Romanet after you insert those provisions, and then this definition of school property would follow. Not that the plans, not that those, not that the actions would follow the school district, the definition of school district property, correct?
Correct. I'm
Okay.
moving that up and then putting the school district property description as its own Romanet number 2.
Which would be after or on line 19 of page 5. So all of the requirements with regard to ensuring state safety and the opportunity for students to learn would be consolidated in one section or one paragraph. And then the following paragraph would define school district property,
Yes,
correct?
correct.
Okay, thank you.
And second,
Do we have a second? It's moved and seconded. Any discussion? Seeing none, all those in favor, say aye.
aye.
All those opposed, no. Amendment is adopted. Further amendments? Representative Bratton.
Thank you, Mr. Chairman. On page 7, line 19 and 20. And going on to page 8, lines 1 and 2, I would propose that we strike that. I'm sorry, did we already do that?
Yes,
Never mind. I withdraw that amendment.
yeah. I think that's it. Thought it was deja vu all over again.
Further amendments? No further amendments? Fixed it.
Question. Yeah, it's
All right, question having been called, please call the roll.
Mr. Chairman, on 26 LSO 197, oh, wrong bill, sorry. Not 197. 26 LSO 88, K-12 Public School Discipline as amended for sponsorship in the 2026 session. Senator Brennan,
Aye.
Senator Olson,
Aye.
Senator Rothfuss, Senator Scott, Representative Bratton,
Aye.
Representative Erickson,
No.
Representative Guggenmoss,
No.
Representative Kelly,
No.
Representative Lawley,
aye.
Representative Singh,
No.
Representative Strack. Aye. Representative Williams is excused. Chairwoman Schuler. And Chairman Andrew.
Aye.
8 aye, 5 no, 1 excused.
Sorry, my turn. The bill has passed the committee. We are now at the order of business of homeschool participation in school districts. Unless we want another lunch.
I can't take it.
The sidetrack.
Yeah, Mr. Chairman, members of the committee. Again, Tanya Heitrick, Operations Administrator, and we're here to present 26 LSO 0197 Committee Formal Draft 1.0 Participation in K-12 Activities. And with that, I will turn it over to Ms. Phillips to walk the bill.
Mr. Chairman, members of the committee, Ashley Phillips, Legislative Editor, LSO. You can see I was trying to get ahead of myself a little bit earlier. 26 LSO 197 requires school districts to allow children in grades 6 through 12 not enrolled in the district to participate in co-curricular
and extracurricular activities, the substance of which is on page 2, lines 9 through 11, where you just see that language added into so participate in any co-curricular and extracurricular activities in grades 6 through 12 offered by the district, including but not limited to activities which are sanctioned by the Wyoming High School Activities Association. A couple of things. This provision applies to all students not enrolled in a resident school district. So that includes homeschoolers, those attending private schools, and students in the ESA program. Oh, never mind. It does not include the ESA. And then another thing, just to clarify, is both co-curricular and extracurricular are used elsewhere in statute. They are not defined anywhere, so the committee may want to consider defining them, but they do have pretty standard dictionary definitions. Section 2, lines 16 through 18, makes the 21-4-506A intro as amended effective for school year 26-27 and each school year thereafter. So that is the upcoming school year to begin in the fall of 26. And the act is effective July 1, 2026. And with that, we'll stand for questions.
And Mr. Chairman, if I could just provide a little bit of context for that ESA discussion, because I'm sure it's going to come up. 2 references. The first is 21-904. B, Romanet 2, capital C, provides that within the parental agreement that they will certify that the ESA student is not or will not be enrolled in a public school upon receipt of the ESA and releases the school district from all obligations to educate the ESA student. And then the second is require an eligible student to withdraw from a public school district before applying for or receiving an ESA. And then the second provision I would point to that supports that particular interpretation is, I just lost it. Is the compulsory attendance laws, and that is 21-4-102, which provides that if you participate in an ESA program, you are absolved from or you are in compliance with the compulsory attendant requirements. And so those 2 provisions would be in conflict if you authorized students taking part in the ESA to be partially enrolled in a school district. For these students, and I'm actually speaking to the wrong bill. So for the next bill, this is what applies. When you have 11 bills, you just kind of, So I apologize. Disregard everything I said.
Representative Lawley.
Thank you, Mr. Chairman. And it certainly is understandable, Tanya, but this bill is to clarify. This bill concerning activities is about any students not enrolled. So that would include ESA students, so homeschool students, private. Anyway, they just not enrolled in the school district. It's that broad and it's always been that broad. That's not new. That's the way the statute has been for 20 to 30 years, I think. But anyway, but that does include ESA in participation in activities sanctioned by the Wyoming High School Activities Association. Correct?
Mr. Chairman, Representative Wally, that is correct. This is just a clarification for those particular students, and perhaps those statutes I referenced are relevant in this case because these students are not required to be enrolled in the school to participate in activities. So apologize for getting us off track, but yes, this is basically just we really mean it, allow them to participate in activities.
Yes, Mr.
Representative Lawley.
Thank you, Mr. Chairman. Yes, that is the issue we're trying to address, is there seemed to be a new creative interpretation that the current statute did not include middle school sports explicitly. I think that's what we're trying to address here, is that but that's a new interpretation this last year, and we're trying to clarify that so that our homeschool families don't have the stress of whether or not their kids can participate in middle school activities. So I don't know, you may not know that, but that part of the stress, but I do, that's what the bill does, is basically clarify that.
Yeah, Mr. Chairman,
Sure.
Representative Lawley, I think that was just the discussion when the bill was requested. And again, apologies for getting us off track.
No problem. Thank you. Further questions? Representative Erickson.
Thank you, Mr. Chair. I just have a quick question. This was brought to my attention before I came over here. And I would ask the LSO to explain it. But is it explicitly stated anywhere or subtly stated anywhere as to that they are required to play by the same rules and they have to abide by the same rules as individuals that are in middle school? I mean, where could I clarify for that? Those individuals that are concerned, and this is the case is one of the parents that is homeschooling their child didn't want the same travel arrangements and things as the team was having to apply to. So.
Representative Erickson, I'm not familiar with the provision that requires them or prohibits them from having different travel arrangements. My understanding would be that would be a district to district decision. I don't think the Wyoming High School Athletics Association's rules and regulations dictate that level of detail, but I'm not certain, and I can certainly get back to you with a more thorough answer.
Okay. Thank you, Mr. Chair.
Representative Lawley.
Thank you, Mr. Chairman. I think part of the answer to the question, not specifically about different travel arrangements, as parents often do in activities, make some accommodations. But there's another part to this statute that you don't see here because we're not amending it, but it has to do with that they will follow the same rules. And it also has prohibitions against districts charging additional fees beyond what an enrolled student would pay for those activities. So there is another part of the statute you're not seeing here because we're not amending that addresses a lot of those concerns and is very explicit, quite frankly, regarding some of the fact of compliance with all the rules of the Activities Association, and again, a prohibition against charging more for non-enrolled children.
Mr. Chairman, I think Representative Lawley, you're referring to Romanet 3. Yeah, which reads, as a condition of participation, the student shall be required to comply with all other rules, policies of the district or any school district activities association applicable to all students participating in the activity and not related to the assessment of fees and charges. And fees and charges are covered in Romanets 1 and 2.
Further Senator Office? No. Okay, sorry. Further questions? Seeing none, thank you. Yeah. We'll now take the Department of Education have comments. Director Shaner.
Thank you, Mr. Chairman, committee members, Dickie Shaner, Nate Tajeski, Department of Ed. Speaking on behalf of the superintendent, she is in support of this legislation. It seemed to rise to the surface after the passage of the ESA bill, and what had traditionally been custom in a lot of districts, but not codified in terms of the junior high school participation. And so this statute just clarifies what the law is on this topic.
Thank you. Are there any questions? Senator Scott.
real problem are we seeing out there? Because it has been the custom. Has that ceased to be the custom? What's the push for needing for us to do this session?
Director Shaner.
Mr. Chairman, through you, Senator Scott, it was about 2 or 3 districts that had real high profile disputes over whether or not the junior high school students were permitted to the junior high school homeschool kids were permitted to participate. That to my knowledge, there may be more, but.
Representative Lawley.
Thank you, Mr. Chairman. Senator Scott, just to provide my district, there was a school district within my House district that this was an issue in and caused quite a disruption in the community, and even non-homeschool parents were upset. But in kind of running all that to ground, and there were other districts, so I think more than 2 or 3 that at least proposed the idea of this new interpretation. But my conversation with the Wyoming High School Activities Association, they agreed with me that their new interpretation was not what the statute said. But because of all the issues that came up with districts deciding to do that, and there was connected with the passage of the ESA bill, that we should clarify that. Ultimately, the district, school district in my district did walk it back and did not require it for this current school year. And that's the way the decision read. And that's what gave rise to, let's not continue to have this hammer held over homeschoolers' heads. Let's, so, but it wasn't significant to me that the Wyoming High School Activities Association said they did not agree. And I think they told superintendents that we don't agree with that interpretation you're giving to this, that it would exclude middle schoolers, the statute that we already had. But it's about clarifying and bringing some certainty.
Thank you. Further discussion? Representative Erickson.
Thank you, Mr. Chair. And again, just another question. I wasn't aware of, well, I knew those high profile cases were going on, but I wasn't aware as to how to exactly get to the answer. But say, for example, you have a homeschool student participating. Who pays? Are districts compensated for that, or who actually pays for their participation, outfitting football players, $1,000? Thank you.
Director
Mr.
Shaner.
Chair, through you, Representative Erickson, in the existing statute, as Representative Lawley mentioned, there are 3 Romanettes that talk about the conditions of homeschool kids participating in sports. Those conditions are: 1, the district may require the student to pay any fees for participation which are required by the Wyoming High School Activities Association. So it's a may, they may or may not charge depending on the district. 2, the district may charge that student an additional fee for participating, but that fee shall be no more than any fee for participation charged to full-time students of the district. The district shall not require that student to pay tuition or to pay any other fees or charges as a condition of participation. And then the third is that as a condition of participation, the student shall be required to comply with all other rules and policies of the district or any school activities association applicable to all students participating in the activity and not related to the assessment of fees or charges.
Senator Office.
Yeah, I wanted to provide a little more answer to that. So that's fees if fees are being charged, but most co-curricular and extracurricular activities at schools don't have any fees associated with them. Most of the time, they're free to students. So in that circumstance, a homeschool student would not be charged. So as to who's paying for it, it is coming out of the School Foundation Program block grant. So it's not being paid for by the state. It doesn't come through ADM. And this is a flaw. This isn't a new flaw for this bill, to be clear, right? Representative is just cleaning up a loophole, basically. So it's not a change from existing statute, but it is important to know because we've talked about it before. We've talked about it briefly on recalibration, although I don't think anyone's talking about doing anything about it. This concept that this is an unfunded expense where you have a real expense associated with homeschoolers. It probably should be funded on some sort of an ADM basis for these out-of-school activities because we are paying a public school service for a citizen of the state of Wyoming, but we don't account for that in any way. So that's more who pays for it. Nobody pays for it. Comes out of the block grant.
Representative Lawley.
Thank you, Mr. Chairman. The number of students is somewhat negligible in districts, so there's that to take into account, but all you said is correct except one thing. Homeschool students have always paid directly to the Wyoming High School Activities Association a fee that the district pays for the enrolled students. So they are that, and that has already been happening. There's never been any question about it. There's never, at least in districts in my district, dispute about that. The only thing that happened is after the passage of the ESA, there was this kind of new, kind of creative interpretation, and it did all the wrong things that we want to see in education. We want to see building of community through education, and we want to see inclusion of students, especially we're talking things like band and choir, really important things that if you don't get those opportunities in middle school, and then because the statute clearly says you have to do it at the high school level, I mean, even under their interpretation, the idea that if they don't get to do it in middle school, it virtually cuts them out of being, for example, in band, participating in high school band, even though even under their interpretation of the statute, they could all of a sudden participate in high school. So literally the interpretation they were given made no sense. And I think the real goal here is to have this clarified. It's been the policy. It's not a policy change. It's just trying to give some certainty to a small group of homeschool students on something that's for some of those families very important. Yes.
Senator Office.
A quick follow-up. I do want to disagree with the fact that I don't think it's negligible. We have thousands of homeschool students at this point in time, and I wish I had the graph in front of us. We were presented it on recalibration, what the total number of homeschool students is. Recall that it went up rather significantly during COVID, and then it didn't come back down. So we're talking a significant percentage, 4 or 5% or something like that of students. So it becomes real dollars. I know my district has a tremendous, and I'm sure a lot of yours do too, but have a very significant number of homeschool students participating. And I don't think we ended up having a problem. At least I didn't hear about it with middle school. I think they're participating in middle school also. Again, this bill doesn't address it, but I do think it's something that the Education Committee needs to take as a serious potential concern that we need to keep in mind, even if we're not addressing it through this legislation, because it can mean a lot to districts that they're having to pick up the bill.
I think Mr. Wilmarth has some information for us.
Mr. Chairman and Senator Office, Matt Wilmarth, LSO Senior School Finance Analyst. I pulled the data from our recalibration meetings, and the Wyoming High School Activities Association does keep track of the number of students that participate in their sanctioned activities. For high schools, in school year 2024-25, 380 students participated statewide in those sanctioned activities. And then for middle school students, 394 students participated. It has increased quite a bit, even over the past 10 or 15 years. But that's the most recent data we have. And Senator Office is correct. If they are not enrolled in any class within the district, they are not generating any average daily membership for which this generates funding through the Education Resource Block Grant model. So the district in that case is paying for those without being accounted for within any funding in the block grant.
Senator Scott.
Well, Mr. Chairman, I just want to comment. I think that the key issue here is that one of the problems you do get with homeschooling is the kids get isolated from their peers and don't get some of the social interaction. This helps fix that, and I think it's very good for the students. And I think that's one of the real reasons for the bill.
Oh, yeah, straight.
Further discussion. Representative Bratton.
Thank you, Mr. Chairman. And I just want to remind us all, we're talking about children here, children who want to participate in band and in cross country and in choir. And it is not, and their parents are taxpayers. So I just wanted to mention that. Thank you.
Question having been called.
I think this is where public comment is.
Wow, I am way ahead of where we are. I am so sorry. Further comment?
We don't, thank you.
Thank you. We'll now move on to public testimony.
We're trying to jump the gun.
Good afternoon.
Good afternoon, Mr. Chairman. Boyd Brown, Executive Director of the Wyoming Association of School Administrators. Not against the bill at all. I think that there is a little bit of a nuance that we need to probably give guidance on, and that is co-curricular activities. So if I'm in band and I have to go to the band class and I'm an ESA student, that causes some problems there. At least from me, from what I'm seeing, we're required to let them in there. But if they're an ESA student, we're not going to get reimbursed for them. Does that make sense? What would normally happen would be we would get that fractional amount of money for that student in band. If they're an ESA student, we will have to be a provider if that's going to happen. And I think that's problematic for districts wanting to bill parents in most districts. And with that, I'll take questions.
Are there any questions? Representative Brad.
Thank you, Mr. Chairman. And actually, I can't answer that because I have discussed that with my superintendents and the finance people in my district. And so as far as how they've always handled it, they've just applied for partial ADM from the department and been reimbursed, no problem. With the advent of the ESA, as you specifically mentioned, what they've done or what they were able to do was to apply as vendors, and then they would be adequately reimbursed again through the department. So I wanted to reassure you that on those, in that case.
Mr. Chairman,
Good.
Representative Bratton, I do agree with you on that. But if I am going to be a vendor and charge those parents and they're in a program that uses all of that money, then the parents are going to have to pay the school district. And I think that puts districts at a bad spot to have to charge parents because we have to be even with all the people that are taking a class. So whatever we charge for a class will be what we charge for a class. And if a student's doing something else and it takes up all that ESA money, where are we going to get the money for that class? I guess that's how I see the conundrum a little bit. And it's going to force every district to be a service provider, whether they want to be or not.
Senator Office.
Thank you. And with this bill, I actually don't think that would be allowable. I think when you explicitly put co-curricular into this, and then you've got the 3 Romanettes that are afterwards that we don't see in the bill, but are in the statute that preclude you from charging any fees that are different from what you would charge others. I don't think your district will be able to do that anymore with an ESA. That might be, I think it would be potentially workable under existing statute. But if it falls into this category, then it's precluded. It's exempted by statute. That said, I'm still not sure an ESA student could, based on the other language of the ESA, where they have to forfeit all of their other obligations, come in and utilize these resources. I almost feel like there's a little tension between that language, where if you utilize these resources, you are no longer eligible for the ESA. And if you've accepted the ESA, you may no longer be eligible for this. And I'm not sure about that. Actually, it's not something we talked about before, but as we're talking about it now, do you have any sense of that tension?
Mr. Chairman, Senator Office, I think that's kind of where it's at. And I think we want to do the right thing. I know that most districts out there would, appreciate their students that are homeschooled that participate. Frequently, we get homeschool students that start coming to high school because parents can't teach calculus or chemistry and some of those things. So I think the issue really came around when we started having ESAs and we were going to have to either be vendors or not vendors. And so I think it does give us a little bit and I think we just need guidance and we'll conform to whichever way we need to do it. An easy way to do it is and this is my opinion, I'm even out there on a limb from not asking any of my other superintendents, is if a student is in a co-curricular activity, just give us the partial ADM. I mean, that seems to kind of take care of it. But I mean, that's a policy decision for you guys.
And that's where doing that would definitely conflict with the way ESA is written. So we would have to go in and tweak both of those places. I think we'd have to write something different for ESA eligibility such that we could bill for a partial ADM, because if you are billing for a partial ADM, you are not eligible for an ESA. That's not to say that's unworkable, but that's a second barrier that would have to come into play, I think. And yeah, I agree. It would be the appropriate equitable solution, right? If you've got a student coming and they want a portion of the time because they want to come to band class, yes, we should let them come to band class. And yes, we should have appropriate funding flow from the state on behalf of the student because they're at that point a public school student and it should be funded accordingly.
Senator Brennan? No. All right. Further questions? Seeing none. Thank you. Mr. Farmer.
Mr. Chairman, Brian Farmer, Wyoming School Boards Association. Not to belabor the issue or anything, but just to provide clarity. Extracurricular is when a student takes something outside of school, football, cross country, something like that. That's not a problem. Co-curricular is where the student has to take a class in order to participate in an activity. That could be band, choir, something like that. That is the area where there is a specific problem. There is a tension between the ESA law and this proposed law with co-curricular classes. And so that's the tension. Those two become difficult. And so as Dr. Brown has said, districts are seeking clarification specifically to the co-curricular. How do we manage that student? If that student is not an ESA student, not a problem. Partial ADM, that's the answer. If partial ADM is the answer for all students participating in co-curricular, that would be our preference, but that would take amendment to the ESA statute as well.
Thank you. Any questions? Senator Brennan.
So I just want to make sure that I'm understanding what you guys are saying, right? The problem here is co-curricular in light of the ESA bill. If the ESA bill didn't exist, this part wouldn't be a problem.
Yes. Mr. Chairman and Senator Brennan, that is correct. Although as Representative Lawley has pointed out, there's another piece of this that is the extension of clarity to the junior high student. So that's a whole other issue, but as to our concern, you're exactly right.
Okay. Oh, go ahead. Okay, so I think this is because we were going through looking at different statutes in the ESA bill. I do see where there's like, what do we do kind of with the ESA? I mean, in my mind, it was like you were going to have to pick one path as a parent. You either were ESA and those ESA funds would be used for any co-curricular activities, or you weren't and you would follow under existing law. Now that's just the way that I like interpret it, but I thank you guys for bringing up this point because I think it's something that if it needs to be clarified, then I appreciate that.
Sorry, Representative Lawley.
Thank you, Mr. Chairman. Here's what I would suggest, first of all, is this statute, whether with or without this amendment raises these questions. So in the amendment, we use more updated terms, co-curricular, but always has existed under the statute is it was written and ultimately the way it was played out practically on the ground was that if you're in band or choir, whether it's middle school or high school, that requires you to take a class in those subjects. So I want to be clear about that. There's nothing about this that's introducing a new topic. It's just creating probably clarity for an issue that does exist as we look at the ESA that's kind of been out there, but it's been there. This amendment doesn't create that dilemma. It maybe highlights it by using the term co-curricular, but in practice, what was actually happening in our districts, whether it was middle school or high school, if you were in band or choir, you were required to take a class, and anyone not enrolled was in those classes as well as participating in that activity. The actual way it worked doesn't change. And I think I'd ask you to agree or disagree with that.
Mr. Chairman, Representative Lawley, I would agree that that's how we've done it in the past. I would say the thing that's changed is that the ESA law passed last year. And so when the ESA law passed, a district either had to become a service provider or they would not get that money. And if they weren't a service provider, the student couldn't take the co-curricular class. And so that's where I see the conflict right now, is that if we're required to allow them to do the co-curricular class, does that require every district to become a service provider? And then I see it as there could be issues with what they're trying to do with the ESA money, and then saying, well, we get to take the co-curricular class, and then we're trying to get whatever we charge for that class. So I guess I'm trying to keep from having that problem, similar to the problem we had with the junior high activities. And I will give you a little background from my perspective on that, if that's okay. I think when the ESA first passed, we had a meeting and we had some discussion about that. And I think some of the guidance that we were delivered as superintendents may not have been as good of guidance as we would have liked to have had. And so I will own that on our side. And I don't think we were not in any attempt to try to cause problems, but it did disenfranchise our homeschool parents.
And Mr. Chairman, if I could just add, I think Representative Lawley asked the question, if this statute isn't passed, does the problem still exist? And the problem still exists. A district is likely to treat the co-curricular as a class choice. So if the statute doesn't change, then the student electing a co-curricular activity, if they're an ESA student, their mechanism is whether or not the district is a qualified service provider. If the district is not, then as Dr. Brown said, they would be excluded.
Follow up.
Representative Lawley.
Yes, and I think we're in agreement. We might be using some slightly different terminology, and I do appreciate your comments about how this sort of the genesis of sort of this backlash, at least that's what it was felt like to parents, not just homeschool parents, with what happened in some districts that really resulted in this bill. So, and I agree that there are some issues about how this stacks up with the ESA. And, but my point really was this amendment didn't create that. So my goal is to amend this, and then I do think we need to address, I don't know now is the time, but to thoughtfully address how these two interplay for ESA students. I totally agree with that. Anyway, I wanted to get that cleared up because we've kind of opened up another can of worms that I actually already knew was probably there, but I don't know quite how to fix it. I honestly don't think the ADM route's the way to go. Probably the route you suggested may be, but that's not really what I'm trying to do with this amendment. So I think we're in agreement that the amendment itself didn't create this issue. It's the interplay with the ESA now and the way it functions. And so.
Mr. Chairman, I would agree.
Mr. Chairman, I don't agree. This bill creates the problem because there's a solution in the absence of this bill. And again, I like the bill. But right now, without this bill, there is a mechanism in place. That mechanism is to charge as a service provider, and that is allowed under statute.
It's not in place because of the way the original statute reads.
It is in place because it isn't being taken into consideration as being this. It's not called into being co-curricular at this point in time. This is vague enough, and in fact, it was even excluded to some degree. So that exclusion was allowing an interpretation that you could use a service provider model and bill them through the ESA. We are making it unambiguous, which is a feature, not a bug. That's what you're trying to do. You're trying to make this unambiguous. Now that it's unambiguous, they can't interpret it incorrectly or through the ambiguity. They have to interpret it as you're going to a class, you're taking a co-curricular activity. They have to follow Romanettes 1 through 3, which says they can't charge for it. And so there isn't a way for them to receive any funding for it. And that is new. That is as a result of this bill.
Representative Lawley.
Thank you. I think the operative part of the bill concerning the ESA is any school-age child who is a resident of a school district who is not under suspension or expulsion by a Wyoming school district and who is not enrolled as a full-time student in the district. That is the operative statement that conflicts with the application of the ESA. Like whether or not this kind of says it does, the ESA students can participate. And so no matter whether we use the word curricular or not, there we go. It was still in effect the same application. So, I mean, if you want to take out that word, I guess we could try to do that or write it a different way. But the operative thing has to do with the fact that if you're not enrolled in the school and enrolled in the ESA, you could participate.
Yeah, Mr. Chairman.
Senator Office.
Again, when you read it all in its old form, and it's talking about specifically activities which are sanctioned by the Wyoming High School Activities Association and which are offered by the district subject to the following. Band class is not that.
Yeah.
And that's why band class, a co-curricular activity, which is a class, can be charged for. When you add co-curricular activity explicitly, all right, I don't think I'm going to convince you of this, but I'm still pretty confident, and maybe I'm wrong. I'm pretty confident that everyone else is probably seeing this problem, and that's what they're bringing as the problem.
Yeah, I agree there's a problem, but the problem exists under the old statute as well. This one was coming down the road because of functionality. Way the Wyoming High School Activities Association sanctioned things included these co-curricular activities, but that's just the way they're built. So whether it was called out as such or not, practically speaking, we were going to have this discussion eventually.
Okay. Well, I don't think we're going to get anywhere. I'm going to continue to disagree. You can as well, but I do have one other point.
Yes.
An extreme example of the way this is going to be structured with the co-curricular activity language is I could have my student take 4 classes or 5 classes and still get my ESA payment with this bill passed. I could have them take, a couple of shop classes, orchestra and band, maybe get them into choir also, as long as they don't conflict during the day. I could do every one of those things and still get my ESA. And I think that's probably getting into the problem space also.
Representative Lawley.
I think that could have already have happened without this amendment. But my point is if we want to address the issue on the ESA, we can make a pretty simple amendment to this amendment, which basically excludes ESA students. I mean, I wasn't intentionally including or excluding them, just to be clear. I mean, that's a policy decision, but I'm just saying that this was targeted at what happened in districts that was a direct shot and effect for homeschool families who are not and do not intend to take the ESA.
Representative Bratton.
Thank you, Mr. Chairman. Just a point of clarification, Senator Rothfuss, you said that you would, when you say you could still get the ESA money, but the ESA money does not go to the individual. It goes to the district. To whom were you referring would get the money?
Senator Rothfuss.
So with the, I could still get the ESA money, I meant utilize the ESA money. And again, that's a much larger can of worms in terms of the debate than what I think we want to focus on. Can I get the ESA money? Absolutely, I can. I can set up my LLC. I can be my own provider. I can sign up for it and I can homeschool my kid, get all the money and spend it. Of course I can get the money. We set it up that way. But I think that's a different debate.
I would say so. Is there any more public testimony? Good afternoon.
Go ahead, finished up. Thank you, Mr. Chair. Chase Christensen, Superintendent, Sheridan County School District number 3. To the conversation around co-curricular and extracurricular activities, and I'm not sure, Representative Lawley, if you intended specifically to write this toward co-curricular activities. To my mind, and as an educator for 14, 15 years and superintendent of a district, when I think about something like a CTSO at the high school level, a career tech student organization like FFA or FBLA, we have agricultural classes that are curricular, and we have FFA, which is a co-curricular activity that students may choose to participate in alongside that course. We have band, which is a curricular course, and we have things like state festival that is a co-curricular activity that students may choose to participate in after they take the band course. Band is not a co-curricular activity. Band is a curricular course that we offer at middle school and we offer at high school. So I think the language of this bill really addresses, and it says shall be permitted by the district to participate in any co-curricular activities. I think you may need some language that students that don't also participate in the curricular course don't get to participate in the co-curricular activity. Because I wouldn't want to see a student that is homeschooled, is not in a band course, and then parents want them to be able to go to district festival, which is a co-curricular activity. And this bill says we have to allow them to go to district festival. They may not have done any of the work behind getting ready to go to that. Just a clarification there.
Thank you. And that brings some great clarity and I appreciate it. I did not choose language. LSO drafted this according to what I was trying to, my desires, but the terms co-curricular, curricular, obviously they're creating some confusion. My original idea was that we just use the same language that you districts use out of rule to get reimbursed for all the transportation for these Wyoming High School Activities Association activities, that for the same language that gives you the right to do it for those middle schoolers who are participating in Wyoming High School Athletic or Activities Association sanctioned activities. So that's what I was trying to do ultimately, but so this isn't the language I told. I'm not necessarily criticizing, but it is bringing obviously some great confusion. So I don't know, Tanya, what your thoughts are to try to bring clarity. And again, if there's an issue concerning the ESA, we can insert a clarity there. I just wasn't trying to deal with that one way or the other, to be honest.
Senator Rothfuss.
Mr. Chairman, I think I have a solution. Striking co-curricular and extracurricular, strike both words. And at that point, it just defaults back to the current interpretation of activities, which actually hadn't been a problem. I think we get back to we're okay now if we do that. And then you can do the charging effectively because it gets to the curricular concepts and everything else. I think it falls back into place. At least it doesn't create new problems at that point because you haven't added any new words to that portion.
Ms. Sidetrack.
Yep, Mr. Chairman, the only observation I would make with that, and I have the Wyoming High School Activities Association handbook up now, and they do refer to co-curricular activities. So both extracurricular and co-curricular. So if your only option is to fall back to that High School Activities Association manual, and activities that are guided by that co-curricular activities, there are some listed within that. And as far as the education saving the ESA students, turns out my misadvice is well placed. So maybe I was just fortuitous in this discussion, I don't know. But this bill does anticipate participation of education of ESA students, so long as it doesn't require enrollment in the school district. So to the point, you know, of the gentleman at the dais right now, band, choir, those things that are partial enrollment, that's not intended to be covered. You know, students in that instance are not able to, ESA students in that instance are not able to participate. They are specifically excluded and agreed to in the parental agreement to not be enrolled in a public school district. And so in the event they were to participate in those classes, the school district would have to be an education service provider, and there would have to be a contract with them for those particular services. That's explicit in the Steamboat Legacy Act.
Mr. Chairman.
Representative Lawley.
Thank you, Tanya, for that. And I think that's a reasonable interpretation. So if others wanted clarity in this space a little more than that, you know, I think there are ways to do that. But the goal of the whole exercise has not been to really address the ESA students. I felt like that was going to either have to work itself out some way or another. So, and I do think what you said there was very reasonable as you read these two bills. Not this bill in particular, but this whole issue of Wyoming High School Activity Section and who can participate with regard to what the ESA says. Again, I'm not sure how the department maybe feels about all that or how they've been interpreting that. But again, I think if we want more clarity there, we can have it. But I think your interpretation is very reasonable in that regard. I can tell you, as I said before, my intent was not whether, you know, to specifically make sure ESAs could participate. I mean, I had, that was not any, you know, I wasn't trying to do that. But I think it is a question that already kind of exists in the statute. But it's to protect these homeschoolers that are not going to take any ESA money. And this was, you know, a cause of quite a kerfuffle in some places and a lot of stress for about their middle school kiddos.
Mr. Chairman.
Sorry, do we have any more public testimony? I believe everyone at the table has spoken already.
Mr. Chairman, you have two online whenever you're ready for those.
Okay, thank you. Let's go online then.
Okay, I've got Lindsay Adam joining us in the room.
Good afternoon.
Hi, this is Lindsay Adam again from Pinedale. The fact of the matter is ESSA did create a lot of confusion for what school district is in charge, not just with curricular and co-curricular activities, but also with testing. So for example, we had families that pulled out of our local district, told us they were homeschooled, fair enough, and then enrolled in band and choir here, sometimes science, because parents don't want to do science experiments at home. And they were enrolled that way for a long time. Then we later found out they were also enrolled virtually with Weston County School District. So now they're dual enrolled in two different school districts. Our school district is paying for their, you know, a couple periods of day plus the cost of their lunch because they're on either side of lunch. And Weston County School District was getting the entire ESA reimbursement. That's where I think issues started to arise because there is a big difference between a homeschool definition student and an ESA student. And when I look at the amendment to this bill, for me, the problem lies in where it says we must provide access to activities for any student not enrolled in the school district. Does that mean the local school district or any school district? Because again, like the LSO mentioned, you aren't supposed to be dually enrolled, but that was what's already started to happen. It's also happening with testing. Some tests, like state required tests, have to be administered in person, like the Wyoming Access Test for ELLs. It was very unclear this year if the local school district, me, a certified teacher, has to administer it in person. Was I in charge of administering the test to our local kids who were homeschooled, but they were actually full-time enrolled in Weston County School District virtual school? And it got very confusing. And my understanding was I could have charged a lot of money to do it outside of school hours as the consultant, which I did not do. But those are things that are problems that were created by the ESA that are not clear to school districts. And I think all school districts want truly homeschooled students to be able to participate and have the social aspect that they're missing out on. But it is hard to be required to pay to educate students when a different district is getting all the money for it. And with that, I stand and yield for questions.
Representative Lawley.
Thank you for that input. I will just respond because I think you're right about confusion and this new idea you've interjected about online in a different district. But concerning the bill we're on and the amendment to that, the statute already provides that it's in a district in which the student resides. So it's a student not enrolled but residing in a district the district shall provide them the opportunity to participate in Wyoming High School Activities Association sanctioned activities. And this is clarifying that it would include middle school as well, which has been the traditional interpretation. So, but this particular statute does limit it to where the child resides, the district where the child resides. So some of the other things that you mentioned are some really great things to flag, but and look at that I can see would create confusion. And I'm not even sure how they decide who gets the ADM or if they split it or what. But any classes, because there's another bill coming up next that has to do with access to classes for homeschoolers, and there already is there's a provision already in our law that districts do get partial ADM for those classes, but this has to do with the issue of access, and so we're going to get to that here in a minute. But anyway, I just want to say on this one, it does specifically restrict to the district where the student resides.
Further questions from the committee? Seeing none, thank you.
Mr. Chairman, you had one more online. She did have her hand up, but now they don't. So I'm just hoping by saying, okay, yeah, they are ready. So Tammy Young is joining the room now.
Good afternoon.
Good afternoon. Can you hear me?
Can.
Mr. Chairman and members of the committee, I appreciate the opportunity to speak to all of you today. My name is Tammy Young. I am from Washakie County, and I am here to advocate and testify in favor of this bill. This has been a very big deal in Washakie County. As Representative Lawley stated before, like for years and years and years, there's never really been a problem including homeschool kids. I've homeschooled. Currently my kids are all enrolled in school, but I have homeschooled in the past and I never had any problem. The school district was very gracious and kind and always helped me. Co-curricular and extracurricular activities, never an issue until the ESA bill passed. And then all of a sudden, it caused a major, giant, big deal in our district. And all of a sudden, last year, kids were being told, nope, sorry, you're not enrolled full-time. You can't be involved in sports. You can't be involved in the play. They were even telling kids that they couldn't be involved in FFA, which I know of a homeschooled family that specifically moved to a different town because they weren't going to allow their child to be involved in FFA. There was a student last year who was homeschooled. He was participating in drama. He was involved in the play, in the spring play, and then all of a sudden, in the middle of the play, he was told the very last week, nope, sorry, you're homeschooled. You have to be pulled out. You're not allowed to be involved. It's been a very big deal here. And so I realized that our district did do some compromising, but they are going under, they are following the interpretation of, you know, not having to include kids if they don't want to. If it's not a WHAA sanctioned thing. And so this bill solves that problem because the biggest deal is for the kids who are not on the ESA bill. It's for the regular homeschooled kids. Currently, one of the, let me just look at the, so Washakie County School District has a home-based education, opportunities for participation in Washakie County. They wrote up a whole thing on it. So currently right now, they are allowing middle schools to be involved in sports, and then they're allowing them to be involved in band and choir. But what about drama? Before, they always used to allow them to be involved in drama, not anymore. So I can tell that there's some quirks that need to be worked out, but there has to be some type of guidance, because right now Washakie County School District is just, they're doing what they want. They're doing their interpretation. So the language in the bill that says, let me go to the bill, that says shall be permitted by the district to participate in any co-curricular and extracurricular. I think that's vital language that needs to be in there. So I'll leave with that, and any questions?
Are there any questions? Seeing none, thank you. Public testimony is now closed. Committee, what is your pleasure on the bill? Moved by Senator Brennan, seconded by Representative Kelly. Is there any discussion? Representative Lawley.
Again, I appreciate the testimony of the last witness from Washakie County to give a little bit of a flavor of the frustration that this has caused amongst parents, and not just homeschool parents. These kids have participated, particularly the sports side of it, in activities since they were about 6 years old, maybe even a little younger, depending on what they started with T-ball or something. So these kids have played together. They've done things that it makes no sense even to these kids why all of a sudden their friends can't participate. So those are the reasons. It has created angst. I think clarity is good, but we have, with some of the language, maybe created some confusion. So I want to offer a couple of amendments that I think respond to for the teacher from Pinedale's comment that might help a little bit her situation. And then I'll offer that one. Senator Rothfuss had one that I think will be helpful as well. But I'm going to suggest on line 7, well, starting on line 6. Oh, I'm sorry, page 2. Line 6, that after the word enrolled, we delete as a full-time student in the district in which the child resides. I think will help a little bit with this idea of, so if a child is enrolled in the part-time in the role, the district they reside, that helps a little bit with whether or not they could go to a different district to participate in something, but which again wasn't really what she was describing exactly, but I think that helps that, taking out the full-time. because they also, are going to be enrolled if they take band. You are enrolling. So, but, and then I'll just leave that at that, just take that phrase out. Yes, on page 2, line 6, as, starting with the word as a, and then going to line 7, full-time student, delete that phrase. Period.
Senator Office.
I don't think that quite does what we want it to do.
Okay.
And I was trying to think of whether an or clause, part-time or full-time student would do it. But if somebody's enrolled full-time, they're excluded from this. And who is not enrolled as a full-time, yeah, in the district in which the child resides. You would at least want part-time or full-time student who is not enrolled as a part-time or full-time student, but I'm trying to figure out if that actually hurts the student's potential access. I'm not convinced it doesn't, but at least we need an or clause at a minimum.
I'll just say this came from LSO trying to address that problem, but,
Mr. Chairman, Representative Lawley, Senator Rothfuss, I hesitate to get into this discussion. But if you are not enrolled in the district, that would include full-time, part-time, three-quarter time, one class. If you are not enrolled in the school district, then the next provision applies. And I think that's important also in the discussion of band, choir, or those co-curricular activities that require a class. That would require you to be enrolled in the school district. This provision applies only to students that are not enrolled in the school district.
Right. So in that instance, I believe the proposed amendment was as a part-time student in the district. And
deleting that.
Yep.
delete not enroll, or delete part-time student as who is not enrolled. All right, I misunderstood. My apologies. That makes sense, and that's just fine. Somehow I got part-time out of it instead of not enrolled. Okay. I don't know how I got that. My apologies. I think that works just fine.
Do we have a second on this?
Yeah.
We do. Okay. All right. It's moved and seconded. Is there any further discussion? Seeing none, all those in favor of Representative Lawley's amendment, say aye. All those opposed, no. Amendment is adopted. Further discussion. Senator Rothfuss.
And I would move to strike on line 9, just strike the new language, co-curricular and extracurricular, so it defaults back to existing language, which would then rely on an interpretation of Wyoming High School Activities Association. So it would read, shall be permitted by the district to participate in any activities in grades 6 through 12. So get rid of the co-curricular and extracurricular and go back to what we've got now.
Moved and seconded. Is there any discussion? Seeing none, all those in favor of the amendment, say aye.
Aye.
All those opposed, no. Amendment is adopted. Further amendments, discussion? Seeing none, please call the roll.
Mr. Chairman, on 26 LSO 197, participation in 6 through 12 activities as amended for sponsorship in the 2026 session. Senator Brennan. Aye. Senator Olson.
Aye.
Senator Rothfuss. Senator Scott. Representative Bratton.
Aye.
Representative Erickson.
Aye.
Representative Guggenmoss.
Aye.
Representative Kelly.
Aye.
Representative Lawley.
Aye.
Representative Singh.
Aye.
Representative Strock. Aye. Representative Williams is excused. Chairwoman Schuler. And Chairman Andrew.
Aye.
13 aye, 1 excused.
Senate needs this bill. I think the Senate wants to carry this bill. Easy one.
It's an easy one.
Just kidding.
26 LSO 193 is passed the committee. We will now move on to, no, that was the wrong bill. 197 is passed the committee. We will now move on to 26 LSO 198, attendance of students in K through 12 schools.
Mr. Chairman, members of the committee, Tanya Heidrich, Operations Administrator. This bill is the one I was speaking to previously. It is 26 LSO 198, attendance of students in K-12 schools. I will turn it over to Ms. Phillips to walk the bill.
Mr. Chairman, Ashley Phillips, Legislative Editor, LSO. 26 LSO 198, attendance of students in K-12 schools, amends the right to attend school statute to explicitly include part-time students as having the same right to a equally free and accessible education in the schools, the public schools. That specifically is on page 2, line 5. It's just a single line added into this statute. And that's the substance of the bill. On line 13 of page 2, you'll see a cleanup where we did some organizational handling. And then on page 3, line 5 is conforming to that cleanup. And then finally, section 2, apologies, lines 11 through 13 states that this will apply to enrollment of children beginning school year 26-27, which is this upcoming school year starting in the fall of 26. And the act is effective July 1, 2026. Kind of going to the discussion, this bill was requested at the end of the last meeting in August. I believe it was Representative Lawley directed staff to amend the law to include particularly homeschool children in being able to enroll in classes in the district. As Tanya was getting to a bit earlier, this does not apply to ESA students because they cannot enroll in a school district.
Yeah, Mr. Chairman, I don't have anything to add to that. I would just refer to my earlier explanation. And so if there are questions about that, I'm happy to answer those.
Representative Lawley.
Thank you, Mr. Chairman. Tanya, I can't find it in my notes, but the reference to the statute where the partial ADM is allowed for this, do you happen to have that? It's okay if you don't, because obviously I don't, but I guess you might just confirm that there is a statutory provision that allows districts to request and receive partial ADM for partial enrollment in the district.
Mr. Chairman, Representative Lawley, I do believe that's correct. I would defer to Mr. Wilmarth. He's the expert on the model. And certainly this applies to non-ESA students.
Mr. Wilmarth.
Yeah, Mr. Chairman, Representative Lawley, this doesn't really impact the model. The districts already account for students on a part-time basis. And so the money is allocated based upon the number of students enrolled in the district. And so if a half-time student is counted amongst the district's ADM, their half ADM would be accounted for in the model and still generate the money that it is today. This is a status quo bill, in my opinion.
Further questions? Representative Kelly.
Thank you, Mr. Chairman. If you could please kindly for me, I apologize, briefly recap what you had said earlier, because I was frantically flipping through the bill trying to find out what it was, and I missed much of what you were saying.
Certainly, Mr. Chairman, Representative Kelly, I apologize for that again. Although it turns out it was relevant in the last bill. So there are two provisions that I would cite you to. 21-2 904 B, Romanet 2, capital C, which provides that in the context of the education savings account and the parental agreement, the parent must certify that the ESA student is not or will not be enrolled in a public school district upon receipt of the ESA and releases the applicable school district from all obligations to educate the ESA student. So in the event that a student is not enrolled in a school district, this provision would not apply. And then additionally, to further buttress that position, if you look at 21-4-102, which is the compulsory attendance statutes, it provides that a child participating in the ESA as specified through the Steamboat Legacy program, who provides notice of that participation to the school, is deemed in compliance with compulsory attendance requirements. So those ESA students have chose a different path than public education.
Thank you. Are there further questions? Seeing none, thanks. Is there any public testimony on this bill? Director Shaner.
Mr. Chairman, committee members, Dickie Shaner, Nate Tajeski, Department of Ed, speaking on behalf of the superintendent, she is in support of this bill.
Senator Scott.
Yeah, we've got a 20-day budget session. It's gonna get it hard to get bills through. What happens if in the next year, if this bill doesn't get through the budget session? Does the bill really change anything that's likely to happen in the real world?
Mr. Chair, through you, Senator Scott, this one I would say is a little more nuanced than the previous one in terms of the fact that we had districts with very high profile disputes. This one is more of a legal discussion about what rights really exist for kids who have given notice to a school district if they're withdrawing, saying we choose to homeschool. Then can you come back to a district and say, well, I want to take 1, 2, and 3 classes? This bill provides some clarity in that situation. And so I can't think off the top of my head that this being like an active dispute somewhere. It's just been sort of a philosophical conversation that's been brewing ever since the ESA bill as well.
Representative Lawley.
Thank you, Mr. Chairman. Mr. Chairman, Senator Scott, I can provide a little on-the-ground color and context, which at the same time, some of these districts were deciding whether or not to allow middle school homeschoolers to participate in Wyoming High School Activities Association sanctioned programming in middle school. They also were taking up the issue of whether or not they wanted to offer classes anymore to homeschoolers. So, for example, in the district, one of the districts in my district, they split the baby, and they ultimately allowed the participation in the activities for 1 year, for this school year. But they did decide that they weren't really going to let homeschoolers take classes anymore. So this, for me, gave rise to an issue of what does it mean about access to the free education? If you partially homeschool, partially use the school district, is that possible? Is it even probably required maybe under the Constitution? Which is, again, all of this is very different. The ESA is not connected with this bill or issue because they are making a choice in taking public money to educate independent of the system. But for homeschoolers, we have provisions for them to get paid for those classes. And so more than one district decided to not pay for the classes, but go ahead at least this year and let them participate in the sports in middle school and other high school activity association activities. So that's why the bill came, is to have this discussion about whether or not we feel that our schools should still be accessible to homeschools, families and students who are not taking any public funds to educate their children. So non-ESA, so if a homeschooling family decides to take the ESA, as Tanya very clearly explained with statutory provisions, they would not be, this would not apply to them. But for homeschoolers who do not, we typically refer to in our district as now, we've kind of labeled them traditional homeschoolers. And whether or not they should have access. We've provided an avenue for the district to get reimbursement for that, but there's nowhere we could find in statute that even suggests they should do that or mandates that they should do that. And so I do think it raises a little bit of a constitutional question. It's not the only question on the table, just even policy, do we want to do that? Should we leave it up to the districts? But leave it up to the districts, we may run into a constitutional issue of access. What does it really constitute to withdraw? And is it fully withdrawal part? Can you, like, what is that? What does that look like in Wyoming? And so that's really kind of the genesis of the bill on the ground.
Sorry, Senator Office.
Thanks, Mr. Chairman. You know what I'm curious about? I've always thought this was generally the right approach, just let people have as much school as they want. But hearing that districts are not wanting to do that, I'd actually like to learn more about why districts might not want to do that. And I'm sort of trying to think of reasons. One might just be logistical convenience of it being a challenge to have Betty's coming in between 10 a.m. and 11 a.m. and then leaving again and then coming back at 1. And, you know, maybe that's part of the problem. But do you have a sense of why districts have opted out? Have you heard any of that? And I'd ask the department the same thing. I don't know what the challenges are. They are being compensated, so that challenge is taken care of. But what would be the cause of concern?
Representative Lawley.
Thank you, Mr. Chairman, and thank you for that question. I would say I go back to the coincidence of timing and backlash against the ESA. But again, I don't think that was the only reason. We did hear in our own district some complaints about some, like you said, people coming and then what if they stay and they need to leave, and that I would just say many of us felt those were general management issues as far as just making rules and enforcing them. And so there were some situations mentioned, but nothing of, in my view, major significance. And I go back to the timing. This all kind of came up, it all did come up at the same time. And these decisions were being made, at least in the districts I was aware of, these kind of were coupled together. And many of the districts, I think, split the baby and said, okay, there's a lot more consternation throughout the community concerning homeschoolers not being able to participate in activities than there were on classes, because some people didn't even know they could go, and then the district would get reimbursed that weren't homeschoolers within the community. So yes, there were, but they were, in my view, general management, administrative problems that had solutions. And there wasn't really much evidence of when asked of any things they had tried to address those things. So.
Senator Office.
And again, I don't know what we're seeing, but this applies to all grades, not just the higher grades. For a class basis, it may, in junior high school, it seems pretty straightforward to enroll an extra student in the math class or something like that. I'm wondering if there's any conversation or concern around elementary level where I, for example, want my child to attend 3rd grade from 8 a.m. till noon. And that could just be because it's more convenient for me, for example. Maybe I've got a gig 8 a.m. till noon, 3 days a week.
Representative Lawley.
Mr. Chairman, Senator Rothfuss, there was no discussions like that. I mean, I guess that's within the realm of possibility. I think some concerns of some of the, parents, it was built to specific things they felt they couldn't supply well for their kids in the homeschool space. So maybe it was a reading deficiency, and they, wanted to attend some classes and things that the district was doing at the grade school level. As you get higher, it really is, math, science, where they're doing labs and things like that, that really are a little more challenging to replicate in the homeschool environment. And, want to, and again, typically our homeschoolers in our districts our district has had really good relationships. But I think there was a lot of misunderstanding about the ESA, honestly, at that time. There was confusion with the original bill file versus what we filed versus, that created a lot of, in a way, understandable angst by the district. But so there kind of became a zeroing in on homeschoolers. So my position is, what the bill is, that they should have access to those. I think it's particularly important when you get to middle school and high school. We want kids to be educated in Wyoming. And I just lean towards access, and this bill leans towards access. Could there be some parameters? Possibly.
And I don't know what would be allowed by rule and whether there'd be flexibility for districts, but now I'm envisioning kind of the drop-in daycare scenario where, this week, I want my kid going to school because I've got a busy week. With free part-time basis, can I do that? Or as I said a minute ago, I just want my kid taken care of because I've got an obligation 3 days a week in the mornings. And so those are the times that I want to use my free drop-in daycare, the school district, because it's on a part-time basis. Obviously, that would be controlled now, but would a district be able to say, that's not the part-time we're talking about?
Representative Foley.
Mr. Chairman, Senator Office, I do think that that is part of the administrative process and rulemaking, and saying, look, to attend means if you want, for example, let's say in the grade school level, help with reading with your child. This is when we do reading, and we do it every day, or we do it Monday, Wednesday, Friday, whatever their schedule is, and put some parameters on, even I would imagine after so many times missed without really any excuse, then you're no longer enrolled. But I do see those problems as solvable. I mean, people can come up with all kinds of ideas, but, and I'm not saying those aren't ones that might be tried, but I think that they can be, because this doesn't really prohibit parameters or rulemaking to keep regular order in the schools and to make sure that the intent of access to education is met.
Further discussion.
Maybe the department wants to weigh in on the issues. I don't know.
Director Shaner, anything else for us?
I didn't hear, other than just, did we have anything extra to add? No, I think that's really at the heart of this discussion. It's a philosophical, it's a policy and constitutional implications here, and of course, practical. And when you said rules, I paused for a minute because I was thinking, does this say we have to do the rules? But it looks like it's the districts. So I think that's probably the appropriate place for the for the rulemaking authority. Thank you.
Thank you. Is there any further public testimony? Online?
No one with their hand up, Mr. Chairman. I'm gonna pause and make sure. Nope, they were pretty quick last time, so I think you're good.
Seeing none, committee, what is your pleasure on the bill? Moved by Senator Brennan, seconded by Representative Guggenmoss. Is there any discussion or amendments? Seeing it. Madam Co-Chairwoman.
Thank you, Mr. Chairman. Obviously, I think, Representative Lawley has mentioned a lot of the things that have come up as a result of ESA, and obviously we know that that's hung up in the courts right now. I'm just saying that we've got some things we got to think about and get to our districts and talk to them a little bit about it, regardless of how long it takes, the courts to decide. So it may be something that we could look at as interim, again, to talk about some of these things that we hadn't really anticipated with our districts. And I just would mention that as a potential for later on. So think about that, committee, and if that's something you think we should probably study a little more, I'd certainly be open to it.
Okay.
Senator Rothfuss.
Thanks, Mr. Chairman. I'm going to support the bill. More education is always good, and this is just trying to get more education. So I appreciate that intent. And I can't see any concerns. If there are concerns, maybe people will let us know, but at this point in time, other than kind of those extreme gamesmanship type concerns, which hopefully individual districts can take care of, I think they can. I think this just helps to make sure that everyone has access to their educational opportunities.
Senator Brennan.
Senator Rothfuss, I just wish I was smart enough to think of those extreme games.
Further discussion? Seeing none, please call the roll.
Mr. Chairman, 26 LSO 198, attendance of students in K-12 schools, sponsorship for the 2026 session. Senator Brennan,
Aye.
Senator Olson,
Aye.
Senator Rothfuss, Senator Scott, Representative Bratton,
Aye.
Representative Erickson,
Aye.
Representative Moss,
Aye.
Representative Kelly,
Aye.
Representative Lawley,
Aye.
Representative Singh,
Aye.
Representative Strock,
Aye.
Representative Williams is excused, Chairwoman Schuler, Chairman Andrew.
Aye.
13 aye, 1 excused.
26 LSO 198 has passed the committee. We are now at the order of business of a very high level presentation on school recalibration with perhaps more details in an email. Oh, short break? All right.
Just for those on the roll.
Oh, breaks on our own.
Right.
5, that's all, 5-minute break? Okay, 5-minute break.
Yeah.
I'm gonna put money on it.
Back at 4.
Ready the best. Oh, yeah. They hold you to the 5 minutes,
Right.
as they should.
All right. 10 minutes. No. Please go ahead.
She asked if you wanted to join them.
Oh. Yes, the meeting will come back to order. Thank you.
Mr. Chairman, Tanya Heidrich, Operations Administrator with LSO. We're here today to discuss the 2025 school recalibration. We'll discuss sort of the status of that, and then we'll also discuss the status of the litigation because that's also relevant. And with that, I'll turn it over to Mr. Wilmarth.
Thank you, Mr. Chairman, members of the committee. Again, Matthew Wilmarth, LSO Senior School Finance Analyst. I've been told to keep this pretty high level, so I will. If you do have specific questions, I'm happy to discuss either on the phone or email. But as you all know, as a result of 2025 House Bill 316 and your statutory obligations, the legislature this interim is undertaking a recalibration of the K-12 education resource block grant model, which is the primary funding source of K-12 public school education funding. That is a committee made up of 6 senators and 6 representatives. 5 of those members actually sit on this committee. And so this committee is well represented on that select committee. The legislature has contracted with Picus Audit and Associates as the prime consultant to oversee and advise the Select Committee on School Finance Recalibration. They have been involved in Wyoming school finance recalibrations and matters since 2005. This is their 2005, 10, 15, 20, 25. This is their 5th recalibration that they've been involved in. And so they are well versed with Wyoming school finance system. And Mr. Larry Picus is the principal that's leading that effort. From a high level, the committee has met 3 times. They've met in June, September, and their last meeting was October 28th and 29th. They have one more meeting, January 22nd and 23rd, at which they will review its bill draft regarding the recalibration of the school finance system. I will not get into the major specifics of that bill draft unless the committee wishes to, but from a high level, they are forwarding a majority of the recommendations from Picus Audit and Associates. And there are various other policy considerations that the committee is undertaking. I'm happy to discuss those with members if you're interested. And so that meeting will be January 22nd and 23rd. That is their final meeting. And then also at the request of the presiding officers, it's anticipated that LSO, whatever comes out of that select committee and its recommendation to the legislature, LSO will put on some type of school or informational session for the entire legislature before the budget session convenes. So you all can kind of get a feel for what that recommendation is. And so we've done that in the past. And so we anticipate doing that again. And so look forward more information on that prior to the convening of the 2026 budget session. With that, I'll turn it over to Mrs. Heidrich to finish up the discussion on the current status of the case.
Yeah. Mr. Chairman, Madam Chairwoman, and members of the committee, as most of you probably know, there were oral arguments in the case on Wednesday here in the Capitol. Both sides presented their view of the appeal, and that is of the school finance case, WEA versus the state. Additionally, on that same day, a motion requested by the state to stay the district court decision was granted. And what that practically means is that compliance with the district court order is not required until a decision is rendered in that case. What I would note is it doesn't absolve the legislature from their obligation to recalibrate. That's a constitutional obligation that the court has identified repeatedly. It's also a statutory obligation So that work needs to go forward regardless of what is in the district court case. All of those documents are uploaded to the legislative portal website. So in the event you can't sleep, there are, I think over 100 pleadings that you can thumb through. So subject to your questions, Madam Chair, Mr. Chairman.
Are there any questions? Seeing none, thank you. Senator Scott.
You say the recalibration is a statute, constitutional obligation. Where do I find that in the Constitution?
Mr. Chairman, Senator Scott, the Supreme Court has opined it is a constitutional obligation subject to the various provisions in Article 7.
There's a statute too.
Yeah, and there's a statutory obligation, but in response to the specific question about the Constitution, the judicial branch has opined on that.
Further questions?
Mr. Chairman,
Senator Scott.
I was unaware the judicial branch would write the Constitution. I always thought it was in the Constitution.
they get to interpret it
I don't see the interpretive.
Pretty sure that's their gig.
Further questions? Seeing none? So, all right, thank you.
Tommy, did you see?
And that's,
You're also on vacation.
we are adjourned. Thank you. Like that.
That.
Do we have nothing?